Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today, what I'm going to talk about are the hearsay exceptions that apply when the declarant must be available. So, the person who made the statement must be available to testify at trial. These are the exceptions that apply when the declarant must be available. And there's other statutes, and I've done other videos that talk about the exceptions that apply when the declarant must be unavailable to testify at trial, and also the exceptions that apply when it's immaterial whether or not the declarant is available to testify at trial. So it doesn't matter if they're available or not available. I've also done another video that talks about the definition of hearsay in and of itself, but just briefly, it's an out-of-court statement offered into evidence to prove the truth of the matter that is asserted. So you're trying to prove the truth of what is being stated in that out-of-court statement. So the relevant statute that applies for the hearsay exceptions when the declarant must be available to testify at trial is, sharing my screen, Code of Evidence, section 8.5. So the hearsay exceptions when the declarant must be available. And again, these are not excluded from the hearsay rule, provided the declarant is available for cross-examination. So there's really two exceptions. I'm not even going to talk about the identification of a person. That doesn't really apply to family law. It's more applicable to criminal law. So the main part that applies is a prior inconsistent statement. So a prior inconsistent statement of a witness is admissible as an exception to hearsay, provided the statement is in writing or otherwise recorded by audio tape, videotape, or some other equally reliable medium. The writing or recording is duly authenticated as that of the witness. So somebody testifying at trial has to identify it as, as it being the person who made the statement. And the witness has personal knowledge of the contents of the statement. So that can be a little confusing. Let me give you an example. So an example is, of this prior inconsistent statement and how it would come in during testimony is, let's say there's a dispute over the income of a husband who's a contractor during a divorce proceeding. And he testifies at trial that, he only receives $20,000 in cash payments from clients, and he declares all of that income. Well, let's say the wife has a recording of, so that's his story, is that he only receives $20,000 in cash payments. Let's say the wife has a recording between her and the husband where he's saying to her, oh, I make $100,000 in cash and you'll never prove it at trial and you're not going to get alimony or whatever. Well, that is a prior inconsistent statement that the wife would, the wife or the witness, the husband himself could admit that he was the person who said it. So that, again, would be, you could establish that it's a statement in writing or otherwise recorded by audio tape. So that is a check that applies. The writing or recording is duly authenticated as that of the witness. So either the wife could, authenticate it as it being the voice of the husband, or the husband himself could admit to it. And the witness has personal knowledge of the contents of the statement. So, whether it comes in through the wife or the husband, they were both there and they have personal knowledge of the statement. So as a hearsay exception, that statement is being admitted to prove the truth of the matter that the husband is asserting. It's offered as substantive evidence to establish that the husband actually earns $100,000 a year in cash payments. So a prior inconsistent statement can come in under that section as a hearsay exception. Now, that's not to be confused with when a prior inconsistent statement comes in for impeachment purposes. So it can come in through impeachment if if the husband is, testifying at trial, same circumstance where he's saying he only earns $20,000 a year. And, you would say, well, isn't it true that, you get the audio recording into evidence and try to establish that, that he said in this other medium that he earned $100,000 a year. So it's a very similar scenario, but that is admissible, that can be considered admissible not simply to prove the truth of the matter that's asserted, that he earns $100,000 a year, but it could be admissible to impeach the credibility of the witness also, which is completely different than it being admitted as a hearsay exception. You're bringing that into evidence to make the judge, question the credibility of that witness and whether or not they can believe anything else that he says, really. So it could be a prior inconsistent statement in a audio recording. The most common example is it being a deposition transcript. So if you took his deposition and he said something different during his deposition, you could admit that into evidence as a hearsay exception. So that's a pretty quick sum up of that hearsay exception. There's really only one part that applies to when a declarant must be available. It's those prior inconsistent statements, and again, the identification of a person that more applies to criminal law. So I hope that was helpful, and as usual, if you have any questions, feel free to reach out to our office.